You've just lost someone, and now you're the one in charge. You walk into the bank thinking, okay, I just need to access the account and start handling things. And that's when everything stops. The account is frozen and no one will give you access. Meanwhile, you're sitting there wondering, can I just use the online login? Can I still pay the bills from this account? What is this banker even trying to tell me? And all of it comes down to one rule that controls everything. And just so you know, this isn't theoretical for me. I'm attorney Darlynn Morgan. I've guided hundreds of families through this over the past 25 years, and it's almost always starts with this exact misunderstanding. In this video, I'll show you why banks lock things down, the 4 ways that accounts are set up, and what you need to actually access the money without running into problems. Before we get into how this all works, think about it like this. Imagine there's a locked box sitting on a table, and inside that box is the bank account. Now, scattered around are all these different keys, a will, a death certificate, a password, maybe even a power of attorney. So you start trying them one by one, and none of them work because the bank isn't looking for just any key. They're looking for the exact combination that proves that you have the right to open that box. And that's what this all comes down to. Not what the will says, not who had the power of attorney, not who has the login or who needs to access the money. What matters is how the account is titled, because legal title controls everything. So why the bank freezes the accounts and how they find out. Let's start with what you're actually experiencing. The account gets frozen and it feels like the bank is blocking you. They're not. They're protecting the account by making sure only the person with legal authority can access it. So the system does the opposite of what you want in that moment. It locks down and it waits for the person who can prove that they have the right to step in. Now, this brings up a common question. How did the bank even know that the person passed away? Usually there's 2 ways. First, through the government. If a benefit like Social Security is paid after death, the agency notifies the bank and requests the funds back. Second, through the family. Someone comes into the bank, often with a death certificate, and asks about the account. That's what alerts the bank. And once they know, everything shifts into that pause and protect mode. Which brings us to the only question that the bank is asking next. Who has the legal right to this account? There's 4 ways that accounts are set up, which can change everything. And this is the part that makes everything click. What happens next depends entirely on how the account is titled. How it's set up determines who can access the money and how. Let's walk through the 4 most common setups. The first is a joint account. This is where you have to slow down a bit because not all joint accounts are the same. If the joint account is titled joint with right of survivorship, then yes, the surviving person automatically owns the money. But if it's a joint account without survivorship, sometimes this is called tenants in common, that's a completely different situation. In that case, the deceased person's share does not automatically go to the other person on the account. It becomes part of their estate. And here's where this gets tricky. A lot of these accounts are set up as what's called a convenience account. Not necessarily to give them the money. It's the parent's money. It wasn't the child's money. They were only on the account to help pay bills, manage things, or make life a little easier. So who gets the money? Well, legally, the title on the account controls, but practically, the intent may have been something very different. And sometimes that's where the lawyers get called in. Next is a payable on death, a POD, or a transfer on death, a TOD. This is where someone is named as a beneficiary on the account. When the person passes away, the money in the account goes directly to that person. There's no probate. There's no waiting on the court. The beneficiary provides their ID and a death certificate, and the bank will release the funds. It's very simple. It's very straightforward. And here's the key point. You don't need to be the trustee. You don't need to be the executor. and it won't matter what the will says. If you're the named beneficiary, you have the right to those funds. The third type of account is a trust account. This is where your role as a trustee actually comes into play. If the account is titled in the name of the trust owns the money, not the individual. So when that person passes, the successor trustee steps in. And now you're not acting as a family member or as a beneficiary. You're acting in a legal role. The bank will ask for the trust documents and a death certificate, and then they will recognize you as the person in charge of the account. The fourth type of account is an individual account. That's where there's no beneficiary and no joint owner and no trust. This is where most of the frustration happens. If the account is titled solely in the name of a deceased individual, this is when the account gets fully locked down. There's no access and no withdrawals, even if you're the trustee. There's no built-in shortcut here. So the bank is going to require a legal process, usually probate or a small estate affidavit, before any money can be released. And this is where most people run into delays, confusion, and pressure from family. Because now you're responsible for handling things, but you don't have the legal authority to access the money. So now we turn to common questions and risk areas. This is where most of the confusion shows up, especially in the first few days. You may be trying to handle things, but you're running into situations that feel unclear. You may think, I have the login. Can I just move the money? And the short answer is no. Login access isn't legal authority. And any authority that you had during life, like a power of attorney, that ends at death. Another one is, should I notify the bank right away? And my answer would be yes. And this is why it matters. If the bank hasn't been notified, the account is still open to activity. So I've seen situations where someone with an ATM card, they kept making withdrawals after death. No one admitted to it, and the money was never recovered. So notifying the bank triggers the freeze and helps prevent that kind of loss. Third, what about checks that are already out there? Well, it may be difficult, but you will want to think through what may already be circulating. I've seen cases where, while mom was alive, a caregiver took some checks. She even had mom sign the checks, and then she started writing them to herself right after mom's death. Once those checks clear the bank, it can be very hard to unwind. This is another reason to notify the bank quickly. It limits what can still go through, and it gives you a chance to catch issues early. This is another reason to notify the bank quickly. It limits what can still go through, and it gives you a chance to catch issues early. Another question I get is, why did the money get pulled back out of the account? If a benefit payment like Social Security hits the account after death, it's often reversed. That's the government agency correcting a payment that shouldn't have been made. So when you zoom out, all of this comes back to one simple idea. The bank is only asking one question. Who has legal authority to access this account? And once you know how the account is titled and understand what that means, then it will make sense, what you can do and what you need to wait on. The next challenge is figuring out what even exists in the first place. Because I can tell you, sometimes there are accounts, assets, or other things out there that no one knows about yet. So in the next video, I'll show you exactly how to find all of your loved one's assets and accounts so you're not missing anything important. So click right here to watch that.